mode in which the trustees can be appointed. So we talked about generally is when the trustee is appointed is usually by deed, and the different ways in which that the clauses that will be contained in the deed would provide for those that are supposed to be the first set of trustees, and that we also mentioned that usually they are part of the deed, they are part of the parties to that particular agreement. And the reason they are part of the trust deed, the reason they are part of them under that particular deed. Can you mute all? I don't know if that's possible, so we don't distract. All right, so we said that the basis, the reason the property is being transferred from the settlor to the trustees for the purpose of the beneficiaries. And we also mentioned that sometimes the settlor can also be a trustee of that particular property when he's during his lifetime. So what is important is that for most of the time, the first trustees are appointed because that is when the trust is being settled. That is when the trust is being instituted. And the experience shows that almost everything regarding how that particular trust is to run is usually contained in the trust deed. And so you need to look at the various clauses in the trust deed and how those particular provisions can be construed, or how they can be interpreted to determine whether who would be the first trustees, who would be subsequent trustees that will be appointed on that particular trust, or in some cases, provisions as to how trustees would be substituted, or how, when a particular disclaim such how that particular vacuum can be rectified. Trustees been on the distinction between usually when we need to look at how subsequent trustees are appointed. The question is, if the first place you want to look at when it comes to appointing subsequent trustees, for first trustees, we know usually it's appointed in the deed. Subsequent
Sir, we can't hear you again, sir.
The internet disconnect. Okay, so can you hear me now?
Yes, sir.
All right.
Yes, sir.
So we said that I can't remember where I stopped now. We were talking about
So you said subsequent trust.
yeah, subsequent. So when you get a trust, when the trust has been settled, the chronology of what happens to that particular trust starts from the trust deed. After the trust deed will tell you who the first trustees are. And that same trust deed usually contains who the subsequent trustees would be, or how those subsequent trustees would be appointed. Now, there are different forms of trusts, such that there are trusts that are created to last for the lifetime of the particular trustees. So we call them trust for life. Now, so what it means is that if I have been appointed as a trustee and I'm supposed to be the trustee for a particular property throughout my lifetime, upon my death, someone else would step in as a trustee. Most of the time, the trust deed would provide for who is standing as the subsequent trustee. So, for example, if you see a clause saying that Mr. A is creating a trust for life, so which means that he will create that trust. That trust will be for the lifetime of those that are the beneficiaries. And after those beneficiary, he will then say, after the death of that particular beneficiary, it will be someone else. So that's the same process. So you want to look at what the trust deed provides. Now, if the trust deed is silent, we have two options. The first thing is you need to look at the provision of the Trustee Act of 1925. And then, and I need to make a clarification regarding the Trustee Act of 1925. We said earlier in our last class, we talked about the Trustee Act being a status of general application. But some of the subsequent provisions of the Trustee Act has now been domesticated, being across the regional level. So we have the property and conveyancing law of the Western region and all that. And then recently we have the Trustee Act, Trustee Law in Lagos State. But what you find in some of those provisions is that they are not comprehensive enough. And so we still have recourse to common law principles that governs the trustees. And we have some of the provisions of the statutes of general applications, especially when some of the provisions of the trustee law or the trustee of the property and conveyancing law in various regions are silent. So we still have recourse to support for the purpose of understanding or having a clear picture of what the rules provide. We make reference to the Trustee Act. Most of the what you find is that most of the provisions of the trustee law and the property and conveyancing are in pari material with some of the provisions in the Trustee Act. So that's why, for the purpose of clarity and for judicial decisions that interpret some of those principles, we have had recourse to 1925 Trustee Act. So that's the relationship between the local provisions of the Trustee Act, Trustee Law, and then the property and conveyancing law within Nigeria. So now, so if there are no provisions in the trust deed relating to any aspects of how the trustees are appointed or how they are replaced or how subsequent trustees are appointed, we refer to the 1925 Act. However, there are instances where the 1925 Act would not be applicable. Why? Because sometimes set laws usually exclude the provision of the 1925 Act. So, which means as a set law, because you don't want to have recourse to the default rules under the 1925 Act, you can exclude the provisions of the 1925 Act in the operation of that of your trust. So, for example, as a set law, I can say that for the purpose of appointment of trustees, I exclude the provision of the 1925 Act. So which means some of the provisions, interpretation of Section 36, Section 34 of the Trustee Act will not be applicable because the set law has expressly excluded the provisions of the Act. In that case, we will then have recourse to if it turns out that the trustee, the set law has not provided for some aspects, we would have, and as especially excluded in the 1925 Act, we would have recourse to common law principles or the laws of the different states. For example, if Lagos State is where the trust is based, you can then have recourse to 1920 the Lagos State law. So it is possible that when you see a trust deed can expressly exclude the provisions of statutes in how a particular trust is managed. And then, so it means that on the construction of the trust deed, we would see how that particular issue will be dealt with. So it is always have at the back of your mind that sometimes it is not automatic that the trustee act will step in when there is a lacuna, when there is an omission trust deed. As long as 1925 Act has not been expressly excluded, we have recourse to the 1925 Act. In the absence, if it has been excluded, then we have recourse to other common law rules that can help us in proper interpretation or proper construction of what the intentions of the trust, that equity will not allow a trust to fail for in interpreting the rules on trustees, appointment, and subsequent appointment. So now, and like I said, I think in the handout that I gave us, we talked about some of those rules regarding how to appoint new trustees and how to discharge trustees. And say, essentially, we said there are three basic occasions where trustees, where it may be necessary for trustees trustees to be appointed. Number one is one of the trustees
kò bí àwọn múùtì wọn jẹ́ kó máa pariwo.
Oh, thank you. I don't know what's wrong with the network. I'm trying to switch the internet. Sorry. Hello. Okay. Sorry about the network. I don't know what's happening. Where was I? So we're talking about some of the cases that justify the appointment of subsequent trustee, or when a particular trustee can be discharged. So sometimes the trustee, we said, deaths can require that new trustees will be appointed, or that a particular trustee is discharged. And we talk about incapacitation. Sometimes incapacitation can be physical incapacitation in terms of an individual trustee, or it can be incapacitation in case of trust corporations, where the trust corporation is declared bankrupt or insolvent, depending on the circumstance. So in the case of an individual, the person is declared bankrupt, and in the case of trust corporation, such person is declared such trust corporation is declared insolvent. So in that case, they are no longer a going concern as a business, so they will now be able to carry out some of the responsibilities under the trust. And then sometimes it can be again need for we are talking about the circumstances for that requires new trustee or discharge of trustee, where you could talk about retirement, which says where someone retires. And I think in the case of trust, you understand that retirement is not that you have stayed long on a particular job, but it's now on the basis that you don't want to continue to serve as a trustee on that particular thing. So on that particular trust, so you can retire. When the trustee retires, another trustee will step in. So those are all where a particular trustee is removed. And we've talked about some of the instances where trustees can be removed in the case of under the law. The law details some of the circumstances in which a trustee can be removed, or where it is possible, where it is required that there's a need to increase the number of trustees. So generally, for example, you would always, like I said, your first point of call when you need to in some of these issues in terms of increasing trustees or that the options to increase or expand of trustees. So those are the 3 or 4 circumstances that warrant the of new trustees or and the discharge. Let's go generally due to incapacity, and then they can also and then in that case. And the basis for your appointment is that most of the time This is frustrating. Sorry, guys. Can you hear me?
Yes, sir.
Uh,
5 minutes.
Yes, sir. We can hear you, sir.
Hello? Okay. Sorry, I don't know what's wrong with the network. It keeps coming and going. Apologies. This so um provides the exception of one trustee. And so usually the corporate as a engage with UBA trustees and informed everything. Sorry, this is frustrating. Anyway, so for example, if you appoint a corporation, for example, UBA trustee, you don't need to have two trustees. Same UBA trustee will act as sole trustee over your particular. That's an exception to the requirement that you should have at least minimum of two trustees. So, and which is that the exception under Section 14 of the Trustees Act of 1925 is when there is when you can have a sole trustee where that trustee is a corporation. So, and that the basis, the justification for that is that as a corporation, they have all sort of expertise who can handle the trust property. So, and so we've also talked about incapacitation. So those are the circumstances that guarantee the appointment of. Now, again, apart from having discussions around appointment of trustees, we need to also, last week I asked us to look at some of the basis, some of the requirements of power under Section 36 and 39, which is, we look at appointments of trustees under Section 36 and 39, which is that as a trustee, you have duties, you have powers, and you have rights. Now, so those are some of those things that are generally attached to a person. Now, the nature of a trust is that it's both a personal type of right and it's also a right that attached to a particular office. So you have personal duty, which is against yourself and other persons. So you're acting in personal capacity, and also you're acting as a form of right on trust assets. So what will happen is that as a trustee, you have a right against or any other person, and if you are managing a particular property, you have rights over other people in a particular. So if you check the decision in Sanders and Votier, Sanders and Votier is a decision in Broadbank. That a case called Brockbank. Brock as in Brockbank. Brockbank. So those are decisions that the Trustee Act tries to determine some of the rights that the beneficiary of a particular trust can bring an end to the trust. For example, it's possible that a settlor sets up a trust and then say that if my child, if the beneficiary becomes of age, so upon becoming of age, the beneficiary can bring an end to that particular trust. So, however, they cannot bring the beneficiaries cannot bring an end to that trust if the purpose is to reappoint new set of trustees, but they will only bring an end or to that particular trust because they have come of age. Is now a condition upon which they can exercise their rights to terminate or retire members of the trustee. The provision of section 19 and section 21 of the Trustee Act. It provides, and section 19, 21, and 22 of the Trustee Act provide for those circumstances. And then in the case of Stevenson and Barclays Bank, it provides for circumstances in which the members, the powers that is usually granted under section 19 of the Trustees Act. So now, what kind of power if we say that now a trustee, how does a trustee then run the trusts? So generally, okay, sorry, before I go into the nature of power, the nature of the fiduciary power, have we looked at tempests, and we have letter state? If we check out the tempest, and did we check out letter state and brass? Hello? Hello? Hello?
Yeah, yes, sir.
Yes,
I'm asking you a question. I know you are there.
yes, sir.
Yes, sir. I read it.
So can someone explain what happened in letter state and what's the decision in that case? And you do it,
Yes, I
you just yourself. Okay,
yes.
I'm listening. Someone should tell us what. Yeah, tempest. Now, tempest.
Hello, sir. Good afternoon.
Good afternoon.
Okay. What happened in Tempest was that the testator died, and he had three trustees. Yes, but one of the trustees that he appointed in his will died before the testator passed on. So the remaining trustees now petitioned the court for the appointment of a new trustee. Am I still audible?
Yes.
Okay, so the remaining trustees, the surviving trustees, now petitioned the court for the appointment of a new trustee who was supposed to be Mr. Peter. So the court in this case now laid out certain principles that will be considered in appointment of a new trustee by the court. So in the judgment given by Turner LJ, he stated three principles. So the first one was that the court will have regard to the wishes of the testator, the person who created the trust. And then the second one is that the court will not appoint a trustee to the interest of some beneficiaries as opposed to others. The the trustee has to be appointed, somebody that will cater for all the interests of all the beneficiaries. And then the third principle is that the court to consider whether the appointment of a trustee will impede the trust or to aid the execution of the trust. So the court now applied these three principles to Mr. Peter as a person, whether he would be a good choice for a trustee. So first of all, the court gave a disclaimer that they have no issue with the behavior of Mr. Peter or as a person, that is a gentleman, but he's not going to be the trustee based on these three principles. So on the first one, which is that the the court will not appoint a trustee when it's clear that it's against the wishes of the testator. So they now stated that in the will, it was very clear that the testator did not want Mr. Charles Henry Tempest to gain from the estate at all. He was supposed to be excluded. But the issue here was that Mr. Peter, who was pushed by who was nominated to be a trustee, he was even nominated by the father of Charles Henry Tempest. So it was very clear that he was supposed to be there to carry out the wishes of Henry Tempest. I mean, kind of speak for him, or and it was clear that the solicitor did not want this particular person to have any interest at all. So on that first ground, he was disqualified. Then on the second ground, which is that he's supposed to act for the interest of all the beneficiaries, it was also clear that since he was nominated to act for Mr. Henry Tempest, he was not going to stand for the interest of the other beneficiaries. So he was also disqualified on that ground. And then the third one, which is that the trustee has to aid the execution of the trust and not impede it. Mr. Peter was also disqualified on that ground because the court reasoned that if he can't work with the other trustees, it was clear that the other ones, particularly, there was one particular one that was against him. I think it was Mr. Fleming. He didn't want Mr. Peter at all. So it was clear that if he was not going to be able to work with the other trustees, it will aid the execution of the trust. Because the whole point of appointing a new trustee is that the objectives of that trust can be satisfied, they can be achieved. So on those grounds, the court disqualified him from being a new trustee in that case.
Your name is Mary Abby.
Yes, sir.
Hello?
Yes,
Hello?
sir, Mary.
That's Mary Abby.
Yes, sir.
Thank you so much. It shows
Yes,
you read it shows you read the case. For those who did not read, I hope you
It's
can
breaking, sir.
see the way she it's the kind of things we are looking for. Now, this is someone else now, not Mary. What is breaking? Eh? What is breaking? Can you hear me? Hello?
Sir, it's better now, sir.
Okay. So considering the decision in Tempest, is there possible to be a relationship between Tempest and Lettersted in terms of considerations by courts, in terms of the discretion that court might exercise in the status of a trustee in a trust? Is that and someone else now, not Mary again? What would be the considerations that might link the decision in Tempest with the case of Lettersted and Brass? What's the relationship, if there is, if any? Anyone? Hello? I hope people have read the handouts I gave you. Hmm? Hello? You are not saying anything.
So I've not been able to read the third case. It's just two I've been able to read. That's the letter
Who has not been able
case.
to read it? Which case have you not been able to read?
The letter state is about removal of the trust. What is letter
Hello?
state? About the trust.
Yes, sir. I've not been able to read the letter stead Mount case.
If you have not read it, you should keep quiet now. Let those that have read it talk. So does it mean the whole class did not read letter state? Hello? Oh yeah, class rep, Sheyi. Someone is in Bariga bus stop. Sheyi?
Yes, sir.
Oh yeah, tell us what happened in letter state.
Sure.
And what are the courts, how do the courts seem to apply its inherent jurisdiction in removing trustees? At least that's one of the names that I know. So what happened in letter state? And tell us what are the considerations that the courts enunciated in that case in handling the removal of trustees. Onifade, you remove your video, we can see you. Someone. Sheyi, we are waiting for you. So he did not read. Sheyi did not read. Can someone rescue him? Maybe he's just trying to Google it and read something out to us now. Can someone else come in? So nobody read letter said, have we? Okay. Oh, you had almost 1 week to read these just two cases. Oh, and you people did not read. All right. So I will take it that you are not interested in reading the case. So I will move on to something else. So we'll see on Judgment Day. So I was hoping that we would finish the discussion on appointment of trustees and some of the challenges from the important case, apart from some of the things that I've given you in the handout. So if you like, you read. If you like, you don't. Now, because we don't have so much time, I would like to go on with to discuss some of the duties of trustees. Now, A trustee, like we've established, can be a person and can also be an entity appointed to hold or manage or administer a trust property for the purpose of the beneficiaries, which is the entire structure of a trust instrument. Or sometimes, like you must have done, sometimes it can be a charitable or ecclesiastic duty. So, which means for some religious purposes and all that. And so, the position of a trustee is a position that that is very sensitive, and it requires a lot of discretion, and it's a position of trust from the whole idea of this whole from the traditional idea of trust. Now, so what it means is that a trustee is in a fiduciary relationship. A trustee has the nature of his duty is a fiduciary one. And such fiduciary relationship is governed by statutes, and it's also governed, and like we said, the statutes include statutes like the Trustee Act, and including in Nigeria, in the case, it also includes some of the provision of the Companies and Allied Matters Act of 2020 as amended, and the Investments and Securities Act. Investment and Securities Act is that act, that statute in Nigeria that governs the different ways in which trusts properties are invested, either in securities or in equities and all that. And it's also governed by common law. So with the statutory provisions and common law principles, and of course, you know, because you are now experts in equity, there are also equitable principles that comes in establishing that fiduciary duty of trustees is not abused. So the duties are hello? Hello? So, and so like I said, there can be the duties of a trustee can be classified into 4 categories. One, which is the most important one, is the fiduciary duties that the trustee has. And the second is the administrative duties. And then the third is statutory duties. And the fourth one is the equitable duties. So fiduciary duties arise due to the nature of a trust instrument, due to the nature of the job, the trust that was imposed on the trustee. Now, and usually all these duties, these 4 duties, they usually overlap, but generally they all work together to deliver the task of administering a trust. And as long, so 2 concepts, 2 principles can be seen from the whole idea of fiduciary nature of the trust, which is that first is that the in excess exercising the duties of the trustee, the requirements of the best of the trustee to act in good faith is essential. Now, as long as the trustee duty of trust, it is what he must be acting what in good faith. Now, the second principle from the whole duties of trustee is that he must act in the best interest of the trust. It must what? It must be in the best interest of the trust. So any action that the trustee is engaging in will be based on, so at every point in time that you are looking at every action of the trustee, you are asking yourself two questions, or you are assessing the trustee on those two focal principles, which is that what, is he acting in good faith? Does it appear like he's acting in good faith? And then the second is he acting in the best interest of the trusts? So if the trustee is able to pass this particular these two thresholds, then the trustee will not have breached his duty under the law. And what's the first point of the fiduciary duties? You know, with duties in terms of fiduciary is duty to be loyal, duty of loyalty. So a trustee essentially must act exclusively in the interest of the beneficiary for the trust purposes. So what it means is that you cannot approbate, you cannot put the property or the interest of the beneficiary at stake. You must act for the purpose of the beneficiary. You must not engage in self-dealing, for example. They want to sell the property of, they want to sell the trust property, and you, the trustee, you are trying to buy, or you are incorporating a company, or sometimes you are acting in a way that is contrary to the interests of the trust or to the interests of the beneficiary. That is a major red flag. So, and self-dealing, or where you put yourself as a trustee in a position where there is a conflict of interest between you and the beneficiary. For example, I think I mentioned in our last class, if you see a trustee engaging in a marital relationship with a beneficiary, presume that can raise the likelihood beneficiary or the entire trust. Those are cases where the loyalty would have been breached under the law. So a trustee, essentially, what the summary of that is that a trustee must not benefit personally in the role of trustee unless there is a from that trust. Except on the construction of the trust deed, it appears that the settlor intends to confer on you a form of benefits. So self-dealing, conflict of interest, and financial benefits over the trust instrument or over the entire trust can raise a breach of that loyalty that we talk about. That's essential. And so, and I'm sure you will know the most important case in this regard, because you, I assume that you have done what do you call it? This course that you do in 300 level now. Boardman and Phipps. Do you remember? I'm sure Professor Boludoku will have given you Boardman and Phipps in the law of agency in year 3 in your city. You remember Boardman and Phipps? Huh? So well, Bodman, if you can't remember again, Bodman and Phipps is a 1967 case. It's a 1967 case. Is 2 appeal cases at page 46. (1967) 2 appeals. Check for those of you that still remember. For those of you that cannot remember. So essentially what the court was saying in Bodman and Phipps is that as trustees, you must avoid any opportunity to personally benefit from the trusts, especially, and if at all there is such benefit, you must disclose such benefits to the beneficiaries or to the entire trust instrument or trust management. So that's the first principle on. Then the second duty, or which is a fiduciary duty under a trust, is duty to act prudently and diligently. Duty to act prudently and diligently. Now here, you are talking about if you see a trustee that is always going for the most expensive thing. Now the trust needs a car to move around. You decided instead of buying Corolla, Toyota Corolla, you decided to buy Range Rover. Instead of investing in things that would manage the fund, and you begin to engage in luxurious living. If you need to fly, so if you are flying from Lagos to Abuja, you are flying business class as a trustee, because you are a trustee, or you are even flying first class. When in your own personal case, you would fly economy, but when it comes to travel for the purpose of the trust, you are flying first class or you are flying business class. So which means that you are not acting prudently in the management of that particular, let's say, or diligently. So trustees, and then you must, that also presupposes that you act reasonable care, skill, and caution in managing trust affairs. So the way and manner in which you manage that particular trust, it matters a lot. And then so, because in law, the law holds that trustees would be held at higher standards. So you will be deemed to have a better knowledge, a better skill in how to manage their affairs, including financial and other forms of activities surrounding that particular trust. So any acts of the trustee or the trustees that appear to be extravagant or that is below standard of care that is required. So if you are not acting like a professional, so the standard that the law imposes on you as a trustee is the standard of an average trustee. The law would not impose a lower standard on you as a trustee because you are managing a particular. So the same standard, the reasonable man standard, reasonable care and skill that is required of someone, an average trustee in that circumstance is what they look. That's when you can be seen to be prudent and diligent. And so if you check the case of SPEIGHT, S-P-E-I-G-H-T, S-P-E-I-G-H-T, and GUNT, S-P-E-I-G-H-T, and GUNT. GUNT as in G-A-U-N-T. So it's an 1883 case, appeal cases. I can't remember the page. 1883 appeal cases. So if you check SPEIGHT and GUNT. So it's a case where the court stated that in terms of the requirements, that what the law would impose on a trustee is the reasonable standard that that trustee would apply in his own personal affairs. So if in your own personal affairs, you will not fly first class simply to go from Lagos to Abuja. then you cannot fly that first class when it comes to traveling for official duties of the trustee. So the law would require that will a reasonable person acting in his own business and in his own capacity, would you have flew a first class to resolve something as minimal or something as simple as just signing a document? So those are some of the standards. That's what that was the holding of the court in Spate and Guns in that we mentioned. And then the third duty of which under fiduciary duty is the duty of impartiality. A trustee must not be seen to want to favor one beneficiary over the other. Who are these people speaking under? Who is the admin? Shay, are you admin? Can you mute these people? Who are these people? Who is Osi Tachika? Why are you disturbing us? All right, so okay. So we're talking. Then I think so. We talked that in duty of impartiality. So essentially, that means that the trustee must act fairly. You must be seen to be acting for the general interest of everyone, and that means that you will not unduly favor one party over the other. So male and female, the same, rich and poor, the different classes of people that are beneficiary must be treated equally. So those are some of the components of the fiduciary duties that the trustee holds. In terms of administrative duties that the trustee holds, the trustee has an administrative duty to carry out the terms of the trust. Here, trustees must administer the trust the way in which the trust deed or the trust instrument must have provided. So any form of deviation of the trustee from how that particular trust ought to have been administered can be regarded as a breach of trust. So if, for example, a trustee, in terms of the chronology of the event, after the trust deed, the first thing the trustee wants to do is to acquire the property, take possession of that particular property, and then tries to begin to accumulate how much is due to one party or the other in managing that particular. So whatever is required of the trustee or trustees in any case must be done according to the terms of that particular trust deed or the particular trust instrument. So the trustees must not deviate. So they must live to the intentions of the settlor of that particular, including how to distribute benefits, on how to including invest that particular property of and that leads to the second administrative duty, which is the duty to invest prudently. If the trust deed provides that a trustee must invest the trust property, the trustee must invest prudently. And prudently is a question of circumstance, and it's also, remember, the basic principle that must guide how a trustee exercises duty is what it must act in good faith, and then it must act in the best interest of the trust. So that also applies for the purpose of the investment, prudent investment by the trustee. So when the trustee is investing the trust property, it must invest in such as if in a professional capacity. For example, if there is a stock, for example, if someone gives me a property and then gives me a property in Banana Island, and then the next thing is that I thought, okay, yes, I have the power to invest as a trustee. I then decided to invest that particular property in cryptocurrency, such that if a week after crypto crashed and then the entire cost disappears, and I cannot account for any, well, you cannot, and then you, for example, if it turns out that the trustee would not, an average trustee would not invest in something that is not tied to any form of products, that would amount to a breach of trust in that circumstance. So those are, you must invest prudently. So prudently can mean investing in shares, either as investing in all sorts of equity, investing in real estate and all that. So those are some of the bases. So that are some of the way, so like a professional will act in investing a particular property. So invest prudently would also mean that the trustee would invest by the Trust Investment Act. Nigeria has a Trust Investment Act. The form of investment would also be in accordance with that. In accordance with that statute. So Investment of Trust Fund Act. So, and then if in the case of Nigeria, you can check the case of Nestle, a National Westminster Bank. Nestle, a National Westminster Bank. It's a 1993 case. 1993 case. 1993 one weekly law reports. 1993 one weekly law report, page 1260. That Nestle, you know Nestle, these producers of Nestle water. So and Westminster Bank. So National Westminster Bank, 1993 one weekly law reports 1260. So that on how the basis upon which the law requires that a trustee would invest in accordance with the Investment Trust Fund Act of Nigeria. Now, so then you also have the duty as a trustee, an administrative duty to keep records of and render accounts. So as a trustee, you have a legal obligation to keep records. So you are spending money you are not recording, and then you have to render accounts to the beneficiaries in terms of annual financial statements and all that. So any deviation record of expenses, acquisitions, investments can amount to a breach of trust, breach of administrative duty. And of course, like we said, it's also under the categories of breach of trust. Now, then one of the, I think I mentioned that earlier, is that an administrative duty that a trustee must also, when a particular estate, when you have been appointed as a trustee, the first administrative duty you want to engage in is to take over the property and accumulate whatever. So, for the properties you need to pay, maybe, for example, because legal title must have been transferred to you under the deed, you then need to go and take actual physical possession of that particular estate. and that's that which gives you both actual title and then physical, substantive and physical title. So if it is monies, you make sure that the accounts, the name under the account is changed to your name because you now have legal title to it. If it is a car, if it's some form of chattels, you need to accumulate all of them because it is after you must have collected all those properties or all the different things, different properties, either real estate or personal properties that comprise the estate. That is when you can then have an effective administration. That's when you'll be able to exercise effective administration of that. Sorry, what's that? What's the noise? Sorry. You people know I'm in a class now. Come on. All right. So now, so that's that's when you can exercise effective administration of that particular estate. Then also after you've taken that, then what are the statutory duties? Statutory duties are generally some of the duties under the under CAMA. If you check the provision of section 830, 830, section 832, and then section 839. 830, 832, and 839 of the of Companies and Allied Matters Act under Part C. You will see some of the statutory duties that the law impose at least in the case of Nigeria on the trustees of a particular trust instrument. So I don't know. Let me stop here for now and then engage with Professor Oni to know if we can continue, and then so I'll get back to you guys. So we can stop here now. If Professor Oni is joining you guys for land law, I'll come back in the next 5 minutes. If it's not, I'll come back in the next 5 minutes. But if he is, I'll also come back and then inform you what his decision is. Is that okay?
All right, sir. Thank you.
Yes, sir. Thank you, sir.